Hi, and welcome to my ALF Training's presentation of Resident Bill of Rights. And we're going to cover the Florida Statutes 429.28, and you can find this online. No resident of a facility shall be deprived of any civil or legal rights, benefits, or privileges guaranteed by law, the Constitution of the State of Florida, or the Constitution of the United States as a resident of a facility. Every resident of a facility shall have the right to A. Live in a safe and decent living environment, free from abuse and neglect. B. Be treated with consideration and respect and with due recognition of personal dignity, individuality, and the need for privacy. C. Retain and use his or her own clothes and other personal property in his or her immediate living quarters so as to maintain individuality and personal dignity, except when the facility can demonstrate that such would be unsafe, impractical, or an infringement upon the rights of other residents. D. Unrestricted private communication, including receiving and sending unopened correspondence, access to a telephone, and visiting with any person of his or her choice at any time between the hours of 9 a.m. and 9 p.m. at minimum. Upon request, the facility shall make provisions to extend visiting hours for caregivers and out-of-town guests and in other similar situations. E. Freedom to participate in and benefit from community services and activities and to achieve the highest possible level of independence, autonomy, and interaction within the community. F. Manage his or her financial affairs unless the resident, or, if applicable, the resident's representative, designee, surrogate, guardian, or attorney-in-fact authorizes the administrator of the facility to provide safekeeping for funds as provided in 429.27. G. Share a room with his or her spouse if both are residents of the facility. H. Reasonable opportunity for regular exercise several times a week and to be outdoors at regular and frequent intervals except when prevented by inclement weather. I. Exercise civil and religious liberties, including the right to independent personal decisions. No religious beliefs or practices nor any attendance at religious services shall be imposed upon any resident. Access to adequate and appropriate health care consistent with established and recognized standards within the community. K. At least 45 days notice of relocation or termination of residency from the facility unless, for medical reasons, the resident is certified by a physician to require an immediate emergency relocation to a facility providing a more skilled level of care, or the resident engages in pattern of conduct that is harmful or offensive to other residents. In the case of a resident who has been adjudicated mentally incapacitated, the guardian shall be given at least 45 days notice of a non-emergency relocation or residency termination. Reasons for relocation shall be set forth in writing. In order for a facility to terminate the residency of an individual without notice as provided herein, the facility shall show good cause in a court of competent jurisdiction. Present grievances and recommend changes in policies, procedures, and services to the staff of the facility, governing officials, or any other person without restraint, interference, coercion, discrimination, or reprisal. Each facility shall establish a grievance procedure to facilitate the residents' exercise of this right. This right includes access to ombudsmen, volunteers, and advocates, and the right to be a member of, to be active in, and to associate with advocacy or special interest groups. Number 2, the administrator of a facility shall ensure that a written notice of the rights, obligations, and prohibitions set forth in this part is posted in a prominent place in each facility and read or explained to residents who cannot read. The notice must include the statewide toll-free number and email address of the State Long-Term Care Ombudsman Program and the telephone number of the local Ombudsman Council, the Elder Abuse Hotline operated by the Department of Children and Families, and, if applicable, Disability Rights Florida, where the complaints may be lodged. The notice must state that a complaint made to the Office of State Long-Term Care Ombudsman or a local long-term care ombudsman counsel, the names and identities of the residents involved in the complaint, the identity of the complaints are kept confidential, and that retaliation action cannot be taken against a resident for presenting grievances for exercising any other resident right. The facility must ensure a resident's access to a telephone to call the State Long-Term Care Ombudsman Program or local ombudsman counsel. The Elder Abuse Hotline operated by the Department of Children and Families, and the Disability Rights of Florida. Number 3A. The agency shall conduct a survey to determine general compliance with facility standards and compliance with resident rights as a prerequisite to initial licensure or licensure renewal. The agency shall adopt rules for uniform standards and criteria that will be used to determine compliance with facility standards and compliance with resident rights. B. In order to determine whether the facility is adequately protecting resident rights, the biannual survey shall include private informal conversations with a sample of residents and consultation with the ombudsman counsel in the district in which the facility is located to discuss the residents' experiences within the facility. During any calendar year in which no survey is conducted, the agency shall conduct at least one monitoring visit of each facility cited in the previous year for Class 1 or Class 2 violation, or more than 3 uncorrected Class 3 violations. D. The agency may conduct periodic follow-up inspections as necessary to monitor compliance of facilities with a history of any Class 1, Class 2, or Class 3 violations that threaten the health and safety or security of residents. E. The agency may conduct complaint investigations as warranted to investigate any allegations of non-compliance with requirements required under this part or rules adopted under this part. Number 4. The facility shall not hamper or prevent residents from exercising their right as specified in this section. Number 5. The facility or employee of a facility may not serve notice upon a resident to leave the premises or take any other retaliatory action against any person who A. exercises any right set forth here in this section, B. appears as a witness in any hearing inside or outside the facility, or C. files a civil action alleging a violation of the provisions of this part or notifies a state attorney or the Attorney General of a possible violation of such provision. Number 6. A facility that terminates the residency of an individual who participated in activities specified in subsection 5 must show good cause in a court of competent jurisdiction. If good cause is not shown, the agency shall impose a fine of $2,500 in addition to any other penalty assessed against the facility. Number 7. Any person who submits or reports a complaint concerning a suspected violation of the provisions of this part or concerning services and conditions in facilities, or who testifies in any administrative or judicial proceedings arising from such a complaint shall have immunity from any civil or criminal liability therefor, unless such person has acted in bad faith or with malicious purpose, or the court finds that there was a complete absence of justiciable issue of either law or fact raised by the losing party.